But do you think that would be a prudent course of action to start creating fundamental rights through the Ninth Amendment, unenumerated now, without consulting Congress?
Senator, I can't speak to a hypothetical about whether or not it would be a prudent course of action for the Supreme Court to hold that there were other rights in the Ninth Amendment. That's
well, the reason I'm asking, Judge, is you've talked a lot today about judicial restraint. And that's kind of like being for children and prosperity. We're all for children and prosperity and judicial restraint. But the rubber meets the road when you get down to, well, what does that mean? What does that mean?
What it's meant for me, Senator, is what you've seen in my opinions, in the way that I've approached issues that have been before me, in my fidelity to the restraints that exist in the law in terms of the exercise of judicial authority. That adherence to precedent, for example, is something that I do, and even in cases, as you heard me discuss earlier, in which they're not binding precedents, I find that the court needs to take into consideration what has previously been determined and not be a policymaker in my decisions.
Okay. Well, here's what's bothering me is too strong of a word. It sounds pejorative. Here's what I'm uncertain about. And please don't take this the wrong way. How do we know? I'm not saying you would do it, but how do we know that, since I can't seem to flesh out this judicial restraint and the limits of it for you, how do we know that if you get on the court, you won't say, well, you know, Congress can't get anything done, and there are all these issues that we need to address. And so I think the United States Supreme Court ought to create all these rights through the Ninth Amendment. What would you say to that if somebody made that allegation?
Well, Senator, I think that I have a record as a judge in terms of having been given responsibility, having looked at cases, having decided issues, and that my record demonstrates how I handle cases. I'm not in a position to hypothesize a circumstance in which a case appeared that raised a question about the recognition of an unenumerated right and whether I would say under those circumstances that I couldn't find such a right because that's a hypothetical, because I decide cases and controversies that come before me, because I'm a nominee and I can't speak to hypothetical scenarios about how I might rule in the future with respect to cases.
Boy, the time goes fast. Let me ask you one other question.
Yes.
This business of having unenumerated rights through substantive due process, there's no textual basis for that. The court just started doing it, okay? I'm not asking you whether you think it was good or bad, because it's clear to me you don't want to share your thoughts on that, and I get it. I'd feel better if you would, but I get it. But don't you think the fact that our founders included a way to amend the Constitution is a testament to the fact that they were saying, here are your rights. We're writing them down. You can all go to the Bill of Rights and read them. And if you want more, we put in a way to amend the Constitution.
I do understand that argument, and there are people who argue that. The Supreme Court has determined that the Due Process Clause
Yes, ma'am.
includes a substantive component.
Okay.
And I understand the critiques of that view.
I'm going to try to get in two more. Boy, the time flies. When does life begin? in your opinion?
Senator, I don't know.
Ma'am,
I don't know.
do you have
I
a
don't-
belief?
I have personal, religious, and otherwise beliefs that have nothing to do with the law in terms of when life begins.
Do you have a personal belief, though, about when life begins?
I have a religious view
Religious belief?
that I set aside when I am ruling on cases.
Okay. When does equal protection of the laws attach to a human being?
Well, Senator, I believe that the Supreme Court, actually, I actually don't know the answer to that question. I'm sorry. I don't.
Okay. All right. You're familiar with the warrant requirement, I know.
Yes.
Okay. What if Louisiana said, we don't want to follow the warrant requirement? Would that be legal?
Are you positing a statute of Louisiana that we're not following, or individual law?
Yeah, it's called a statute.
Well, Senator, I'm thinking about all of the potential legal arguments that could be made. I can't answer the hypothetical about whether or not it would be lawful or unlawful.
Can you think of an instance where a state could say, we're not going to follow the warrant requirement. We're going to write our own warrant requirement?
I've never heard of that happening.
Yeah. What if Article 1, Section 5 of the Louisiana Constitution is our state unreasonable searches and seizures? Couldn't we say, we're not going to follow the federal interpretation? We're going to make it stricter under the state constitution.
Well, the state can also.
And in fact, under the state constitution, we're going to say a warrant is required in every instance. Don't give me this stuff about plain view and hot pursuit. You serve somebody, you better go stop and get a warrant. Now, I'm not saying Louisiana would do that, you understand? And I'm not saying they should or shouldn't. They can do that, can't they, under their own state constitution?
They can provide more protection than the federal government. Yes.
How can they get away with that under the supremacy clause? You got to go fast because Durbin's about to cut me off.
Yes, I'm sorry. How can they get away with providing more protections for people?
Yeah, under the supremacy clause.
Because it would depend on whether or not it conflicted with federal law. It doesn't conflict, I think, if the state provides more protection.
We call that the adequate and independent state ground doctrine, right?
Yes.
Okay. All right, I'm over, but only about 22 seconds. So I'm going to land this plane, and we'll take off again tomorrow.
Thank you.
Thank you.
Thanks, Senator Kennedy. Senator Padilla.
Thank you, Mr. Chairman.